I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm pulling up parking now. It seems like you're practicing law from the bench. I'm going to respect your courtroom, but I disagree. Yes.
Sir, you have to stop interrupting.
Penalty and perjury.
Sir, if you stop speaking when I'm speaking.
Your Honor, he's coercing. And since there's no statute of limitation for fraud, he's wasting judicial resources. Honor my counterclaim to dismiss this matter.
So based on the proofs on the record, the court does find that.
All right, folks, today we're looking at one of the most frustrating courtroom moments involving a sovereign citizen. This case features Judge Hillman, who took a different route than usual. He stayed calm and patient instead of shutting things down right away. That alone makes this one worth watching. But here's a serious question. When should judges stop entertaining these kinds of arguments and start holding people accountable for wasting the court's time? Personally, think the judge could have taken a firmer stance. But I won't give away too much. Let's take a look and see how it all plays out.
You say I'm driving a vehicle. Yeah, you need me to stop? I
need you to stop, sir. I can't have you driving while you're.
15 seconds, I can pull it back up to my family house.
No, I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm pulling up parking now. I'm parking, right? 5 seconds. Okay, I'm done, Your Honor.
You recall in reviewing your business records if a foreclosure was conducted with regard to this property?
Yes, it was.
Objection, Your Honor, hearsay.
Okay, overruled. You may respond, sir.
On what grounds? So I could maintain the error for the record. When I appeal this don't go accordingly?
Okay, it's a business record, sir. That's an exception from
first-hand knowledge. Was he there at the closing table?
Doesn't need to be, sir.
Your Honor, it seems like you're practicing law from the bench. I'm gonna respect your courtroom, but I disagree. I disagree is tremendous. So, okay. Court reporter, can you please note that the honorable judge, I'm stating he's practicing law from the bench without facts.
But your objection is part of the record, sir. All right. You may continue, Mr. Duher.
And is this a true, correct, and complete copy of the sheriff's deed of mortgage foreclosure, to the best of your knowledge?
To the best of my knowledge, yes.
And is this sheriff's
objection, Your Honor? Can he vow to that under penalty of perjury? That's the original document.
Your Honor, he stated this to the best of his knowledge.
No, under penalty and perjury, can he contest that that is the original document with the wet blue ink signature? Penalty and perjury.
All right, sir. That's not the question. The question is whether he can identify the document.
Under penalty and perjury, can it be yes?
Sir, you have to stop interrupting.
Penalty and perjury.
You can make an objection, but once you've stated your objection, you have to stop.
Yes, Your Honor.
All right.
And for the record, Your Honor, I do have counsel coming for this next court date. They obtained, as soon as he get back in the country, he will be jumping in to take care of this matter further. So I'll ask if you just give my counsel some time before any permanent decision is made so they can review these books, all interrogatories, so we can make a fair decision. Because I'm not arguing it's a debt, and I've been trying to honor the debt, Your Honor. I'm not arguing that it's a debt. I done did everything possible to honor this debt. They have not been in compliance with it.
And Your Honor, I would object to that, given this would be our third hearing, and he had ample time to get counsel.
Objection again.
All right, let's take one issue at a time, gentlemen. I can't be expected to remember 3 or 4 objections all at the same time. I'm going to overrule the objection on the basis of a business record exception. As to the request to adjourn the matter for Mr. Bay to retain counsel, I'm going to deny that request. Mr. Bay is
on what grounds, Your Honor? Because I never got served directly.
If you stop speaking when I'm speaking, then I will state my grounds.
Is exactly where I get frustrated with how some judges handle sovereign citizens. They really need to be much firmer in situations like this. Now, don't get me wrong, this judge seems like a decent person, but he's being way too patient here. You can tell the defendant is just stalling and taking full advantage of that patience, at some point. The judge needs to step in more strongly, maybe. Even warn him about being held in contempt. Watching this kind of behavior go unchecked is honestly exhausting. I don't know about you, but to me, it's crystal clear that this guy isn't serious. He's just trying to waste time and avoid the real issues. Let me know your thoughts. Let's get back into it and see if the judge finally puts a stop.
And so
I never requested that. You stated that, Your Honor. This is my first time requesting any adjournment to bring in incredible counsel who can handle this matter fairly on my behalf.
At this point, I don't even see that you have standing to participate in this case, although I guess we will get to the proof on that issue. So,
so Your Honor, you don't have my deed of records right there. You don't have me as a deed owner. You don't have me as a certificate owner in the record. I put all that on the record. So for you to say I don't have standing is kind of unfair from my understanding.
And was that redemption date September 27, 2021?
Your Honor, he's coercing. He's coercing Mr. Dewhurst.
As a government record and or document recorded with the applicable recorder of deeds for this this document.
Okay. Any objection to that, Mr. Bay?
Absolutely objection.
Okay. And what's the basis for your objection?
He's a third-party debt collector. He's not a real party in interest, and he has no firsthand knowledge of any of the affairs that took place with this mortgage or at this closing table. And that Mr. Dewhurst he's not eligible to bind a corporation. Do he have the status of a CFO or a CEO in that company?
Okay, so the objection is that this witness doesn't have the
firsthand knowledge to any other matters.
Okay, all right. So the objection is overruled.
And has Carrington ever conveyed any of their ownership?
Objection, Your Honor. Objection.
What basis, sir?
Rightful owner as the title, rightful owner as complete ownership of the property. Can't just take away my interest like that without facts. You guys still have not had no verification of debt. What you have in your hands, Your Honor, we don't reached out. They cannot verify that debt, and they cannot verify that they ever loaned Rachel Brown and Matthew Brown any money for this mortgage. They can't. They can't prove that, and they haven't yet. And I've been waiting. I just want to know if they're a real party in interest, are they a real creditor in the amount, so we could handle any financial obligation if they are yet to prove that. Like you said, I got the deed, and it's sealed by the county records. I have the warranty deed as well, and it's sealed by the county records. Objection. Can you prove I didn't redeem and attempt to redeem? Can you prove that it hasn't been corresponding and negligence on you guys' behalf?
Overruled.
The property was foreclosed on and Carrington took control of it.
Okay.
Objection, Your Honor. How can you take control over something that...
One thing. Just don't get about this hearing is why, given what's at stake. This man thought it was a smart move to represent himself. I mean, his home is on the line. And instead of hiring a lawyer, he decided to just shout objection over and over like that would fix everything. That's not how court works. The legal system is complex, and there's a reason the Sixth Amendment gives you the right to an attorney. Watching someone gamble everything without legal help just to prove some odd point is honestly hard to watch. What do you think? Can you imagine any situation where this actually makes sense? I sure can't, especially based on what we've seen from other sovereign citizen cases. But who knows? Maybe I haven't read their whole script. Anyway, let's get back to it and see how this plays out.
I got the taxes in my name. I've been staying there the last year, and I have the deed and the warranty deed again for the record.
May I ask a question that would help?
You may, Mr. Johnson.
Objection, Your Honor. He's about to coerce him again. The question was clear. He could answer that on his own. He said he had 30 plus years of experience. This shouldn't be his first rodeo. He can answer that on his own.
Was there any redemption made by any party during that time?
No.
And none of your reflect.
Objection.
None of your record.
Objection.
And once again, you have not.
What's your objection?
That's not credible. That's not credible.
Sorry, this is not your time to ask questions, Mr. Bay. Mr.
Okay,
Johnson,
let me know when I'm credible to ask questions.
All right, Mr. Johnson, any other questions?
Has Carrington ever conveyed ownership of the subject property to any party?
No.
Thank you. No further questions, Your Honor.
Objection, Your Honor. Matthew Brown, not the owner at the time that they
Mr. Bay, this is your time to ask questions. So if you want to ask any questions to Mr. Dewhurst, you may ask questions to Mr. Dewhurst.
Okay, Mr. Dewhurst, is it not law that 15 USC 1692G requires verification of any debt?
Your Honor, I object as to relevancy.
Again,
okay, what's the relevancy, Mr. Bay?
I'm establishing bounds for fraud. And since there's no statute of limitation for fraud, I'm going to make sure if they're not the original creditor, that it's fraud.
You didn't respond to the relevancy or how this is relevant.
The relevancy of 15 USC 1692G, it binds any corporation or anybody who's saying there's a debt or a balance to verify.
Okay, so this is the time to ask questions, not to argue law.
No,
So
I'm not trying to. I'm asking a question. That was a question.
You have a question regarding the facts for Mr. Dewhurst. Okay, you may proceed.
Yes. So again, Mr. Dewhurst, under 15 USC 1692G, do you have to verify a debt?
I'm going to have to object again regarding relevancy, Your Honor. This is, unfortunately, he does not have standing to bring any claims of verification.
Objection. I'm a real party in interest. Objection, Your Honor. He doesn't have any standing. He hasn't proven he's more than a third-party debt collector yet.
Your Honor, after the foreclosure period ran,
Your Honor, we don't know if this is credible foreclosure. Can I ask my questions, Your Honor?
All right, gentlemen, you cannot speak at the same time.
Next question. So, Mr. Dewhurst, are you conscious of the verification of that letter that been sent to your company twice that I sent with behalf of Matthew Brown and Rachel Brown that they're yet to respond from? My notary sent it. The notary republic sent it.
Your Honor, I would have to object.
Yes or no?
Sir, you have to let Mr. Johnson state his objection. Mr. Johnson, what's your objection?
Your Honor, she's asking the witness to respond to a vague request if he has any notice, but I would ask that he would only ask as it relates to the business records, Your Honor.
Objection, Your Honor. I sent that to the business and record department, and I sent it attention to the CFO of the company.
That's an argument. That's not a question. This is a time for questions.
Anyone else thinking it's long past time, this man gets a lawyer. I'm honestly starting to feel secondhand embarrassment just watching this. And honestly, I'm a bit surprised the judge hasn't stepped in more firmly by now. At what point do you just call it, oh, this man has said objection over 30 times? Not one of them made any legal sense. It's almost like he thinks if he says it enough, the court will just throw in the towel. But that's not how it works. The whole point of contempt charges is to deal with people who refuse to follow courtroom rules and just drag the process out at this stage. He either needs to be held in contempt or evaluated to see if he even understands what's going on, because something clearly isn't clicking. What do you all think? Would you have charged him with contempt already, or just let him keep going with this bizarre routine? And have anyone's been counting how many times he's said objection? I'd love to know.
No, that was in the form of a question. You didn't let me finish, Your Honor.
Okay, well, you can't ask multiple questions within the same question.
Okay. Well, Mr. Dewhurst, what was the problem answering the verification of that letter? If you have that in the record. So we've been asking for the original.
Objection, Your Honor. He stated that he was not aware of a letter.
You're right. Correct. So I should say then, moving forward, is there a problem producing the original contract with the wet bluing signature from Rachel Brown and Matthew Brown? If you have that in the records.
Okay, so you have a question for Mr. Dewhurst?
Yes, Mr. Dewhurst. Is it fair to say you cannot prove that the original, you don't have access to the original copy of the note of the mortgage?
Yes, I'm
under
sure.
penalty and perjury. Do the company have it, Mr. Dewhurst?
So you may ask another question.
And also, Mr. For you, Your Honor. So it's also credible and fair to say he has no firsthand knowledge of anything as well.
Okay, so that's an argument. That's not a question. Okay. So yeah.
All right, I'm learning. I'm sorry, Your Honor. Thank you for your patience. So Mr. Dewhurst, under penalty and perjury, can you confirm that your company followed all GAP procedures with this process?
Objection, Your Honor.
So I guess the last question, again, I just want to confirm that Mr. Dewhurst, you have no firsthand knowledge of the Carrington Mortgage being the creditor in this loan for this mortgage. So that's still kind of broad, Your Honor. I want for the record for him to say, are you guys the creditor, or you don't know?
Asked and answered.
No, that's not asking and answer. I'm asking directly, Mr. Dewhurst, is Carrington Mortgage? Can you confirm they're the creditor of this loan or this note, or you don't know? And I'm asking you that for lawful reasons.
And so by bidding the highest in the sheriff's sale, what interest does that give Carrington then in this proceeding?
We're then the creditor.
Okay. All right.
Allegedly. So that is true if that's the case. But if, Your Honor, or court, if Carrington can never prove they ever issued anything, is it fair or is it lawful to state that they never have the right to say they hit with the highest bidder with anything?
Any more questions for Mr. Dewhurst, Mr. Bay?
Not at this moment, Your Honor.
Okay.
Not at this moment. I'll let my counsel deal with that.
Okay. Does the plaintiff rest?
Yes, Your Honor. But if I may just conclude with a couple things, if that's okay.
Well,
objection, Your Honor. Statement and brief from counsel is sufficient for summary judgment. And
to show that there was indeed a foreclosure sale conducted on March 25th, 2021.
Objection, Your Honor.
And this is final argument, so that you can't object to that.
I'm sorry, Your Honor.
All right. Additional final state arguments, Mr. Bay?
Yeah, again, Your Honor, he's wasting judicial resources.
The plaintiff claiming the court is wasting time. Seriously. I can't even tell if he genuinely doesn't understand what's going on or if he's just messing with everyone on purpose. Let's be real. He's the one holding everything up. The judge, the lawyers, the court staff, everyone is stuck here because he refuses to follow basic rules. And we all know what he's trying to do. It's dragging things out, hoping that by delaying long enough, his problems will just disappear. But that's not how court works. You don't get to shout objection 100 times and expect the case to vanish. That's the issue with a lot of these sovereign citizen types. They love talking about their rights, but completely ignore their responsibilities. The law is very clear. If you don't follow procedure and waste everyone's time, the consequences are on you. But accountability, that seems to be a word they've never looked up, just like many others. What do you think? Is he just completely lost? Or is this all part of some act?
Coming with this because, again, I have proof on file and on record, correspondence. We try to resolve this matter. At this time, I would like to bring my counsel in. They'll be back in the States in a couple of weeks. And also, Your Honor, can I request that Mr. Johnson put his bond on file? Can I get his bond information, his liability bond for this matter as well?
Okay, no, that's not an issue in this case.
I ask for you to just honor my motion, honor my counterclaim to dismiss this matter, because they don't have, it's not nobody with real party and interest on this line right now. Nobody with firsthand knowledge is on this court case right now that can speak and contest to what's going on. So with that being said, I ask to adjourn this matter or dismiss this matter because for failure to state a claim upon which relief can be granted.
An individual who's identified himself by the name of Amate Bay claims to have a possessory interest in the property, though he did not present any proof on the record today of any interest that would make him have standing to contest this mortgage foreclosure and this suit for possession. So based on the proofs on the record, the court does find that Carrington Mortgage Service LLC does have the right to possession, and therefore a judgment of possession against Amate Bay and all occupants of the premises is granted.
What is my time frame to no, can you just for the record, so there's no contract with Amate Bay and Carrington Mortgage in this matter, right?
Sir, I'm not going to explain my ruling to you. I just ordered that the Carrington Mortgage would have the right to get an order of eviction, removing all occupants from the premises.
That's fine, Your Honor. I'll make sure it get overruled in a higher court. Thank you.
Okay. All right. That's all for the record. Thank you, gentlemen.
Thank you,
Your Honor. Have a nice day.
Honestly, I'm starting to wonder if this man even understands what he's doing. There's just no way he truly believes this is going to work. And the most unbelievable part, he looked the judge straight in the eye and confidently said he'd just appeal and get the decision overturned like it's some kind of easy fix. But that's not how appeals work. An appeals court doesn't just undo a verdict because you didn't like it. They only step in if there was a real legal error, like a violation of your rights or a misapplication of the law. Otherwise, you're just wasting more time and money. In my opinion, reality is going to hit him hard. And honestly, I think the judge should have been tougher. Maybe I'm being too critical, but it felt like the judge let him get away with too much. Still, it's clear this whole situation was a perfect example of how not to act in court. If you ever find yourself in legal trouble, don't take cues from a sovereign citizen. That said, even though I was hard on the judge, I've got to give him credit. His patience was incredible. But in the end, the law doesn't just bend because someone refuses to accept it. These folks can argue all day, but the court doesn't follow imaginary rules. It's like denying gravity. No matter what you say, it's still real. All right, I'll wrap things up here. Let me know in the comments what you thought. Was this guy just playing games, or did he really think he stood a chance? And if you enjoyed the video, don't forget to like and subscribe. I post new content every day. Thanks for watching. Take care.